Hello, my name's Tom Carhill. Today's the 17th of October 2010. I just want to make this video to share a bit of knowledge that I've come across recently. Take from it what you will, but this is just something that I wouldn't have known unless I'd found out about it. It's one of these things that, everything's easy when you know how. So I'll just fire straight into it. The subject matter is, if you're dealing with a solicitor or a barrister or a solicitor who has rights of audience, often known as an advocate, what's the difference? What are your options? What is your best option right now? And some various other things that fall out of this particular subject. Right now, in England, you've got the Solicitors Regulation Authority, which is part of the Law Society. They regulate solicitors, right? Now, solicitors solicit with the public like prostitutes solicit, so they interface with the public, right? Barristers traditionally don't solicit the public, and they're not allowed to. Now, the reason for that is they're meant to be adept at dealing with matters in the High Court, and the High Court, obviously, each big town in England has a High Court. Sometimes they have what's called a district registry, right? And that means that it's got there was a District Registry Act, I believe, about 200 years ago, 1760 or something, and it's basically saying, like Liverpool, Manchester, places where there was big trading centres, they set up what was called district registries, and that was where you had like a circuit judge from the High Court would go up there, so you could have High Court cases in Liverpool without, so it'd be exactly the same as going to the Royal Courts of Justice, but it'd be up there. So that's where district registries come from. Like, for instance, Chatham, I think it's called Medway Town Court now, Medway County Court, right? So that's like a civil court, but it's a district registry, right? However, very bizarrely, it's a complete anomaly to me, it doesn't hear money only claims. So it's a district registry, it's a civil court, not a magistrate's court, yet it's a district registry, but it doesn't hear money only claims. Completely bizarre. But the worrying thing is, it seems the only reason it's been made to be a district registry is because it sees family cases, so family law cases, as though it's the High Court, but you can hear them in this little pokey court as though it's a High Court. So that's another thing. So remember, you've got like magistrates' courts, which came in during, I think it was World War One, when you used to have the right to go up to the High Court and have a jury and all that stuff, but you could actually say, look, I'll go to the magistrates' court instead. And the little booty bonus was you couldn't get more than, I think it was a 2-year sentence. So lots of people wanted to go to the magistrate court because they're likely to get found guilty. They couldn't get such big sentences. But of course, the magistrates' court, you don't even necessarily see a proper judge. So, but that's the criminal-based stuff, and things to do with road traffic offences and all that sort of stuff. So that's the magistrates' court. In the civil court arena is really what I'm focusing on here. So let's say you've got a problem. You go to a solicitor traditionally. So you'd phone up the Law Society via the Solicitor Regulation Authority, and they'd sort of say, name a solicitor who specialised in that area, apparently. Right, that's what they'll say. So basically, it's like looking up the Yellow Pages, but you phone them up and they'll tell you one in your area, or one that's in London who specialises with that thing normally. Right, now, the thing with that is, solicitors, if it's something important, they're allowed to go to the county courts, the normal county courts. They're allowed to go and represent you there. They're allowed to be your advocate in the county court, but they're not allowed to go to High Court for High Court matters. So it's about a lot of money. They're not allowed to deal with it. All they're basically allowed to do is go to the county court and whinge about, give me the money back. That's basically all they can do, and say this is why, this is why, this is why. And you can do that yourself. Also, they're legally entitled to put paperwork in on your behalf, whereas I couldn't put paperwork in on behalf of my brother or my dad or my mum, or I could put it in on behalf of children of mine, or someone who was basically like, I've got some kind of legal paperwork from the doctor saying that I'm basically looking after their affairs, then it's allowed. Or if they're very sick, there's also, but apart from that, you cannot do it. Sometimes it seems there has been some cases where the courts are quite lenient on this and actually let people deal with this. And there's been an interesting case that I came across where very crooked dealings by the looks of things. Somewhere in Wales, this guy had got a cost order against him. That's like, not as in not, he hadn't had to pay cost to the other side. This was cost of the other side's lawyers. And they allowed some guy who didn't even have any legal qualifications, wasn't legally qualified, and he'd gone into the court for a kind of cost assessment hearing. He just walked in off the street, and for some reason, because they were fitting this guy up, they thought, fuck it, we'll just let this plank just walking off the street, completely illegal. He knows it's illegal. He's not allowed to do it. He's effectively impersonated solicitor. Should have gone to, could potentially go to prison for it. They just let him off because, again, with all these rules, they break them constantly. But the point is, so you're not allowed to hand in anything on behalf of anyone else, even just handing in a form that the person signed. You possibly might be able to get it, but you're not allowed to deal with it on their behalf. Maybe you're allowed to just hand it in at the desk. Maybe they wouldn't even ask actually, but technically speaking, let's say you're a barrister's clerk, you're not allowed to go and hand in paperwork at the court. You've got to get someone who's legally qualified to go and do it. Now, as I said, I think that might be because generally speaking, barristers' clerks will be dealing with things in the High Court, and in the High Court, you're very likely to have to go to speak to a master. Now, a master's like a secretary, but they are a High Court judge. So they're a High Court judge, and they sit there as a secretary. So effectively, I don't know what the word would be, but that's their function. They basically make sure that paperwork you hand in goes to the right place, and it can be heard along the lines of how a judge would want to hear it in the High Court process, because of course you've got applications for this, applications for that, applications for this order, applications for a this hearing or a hearing about that. There's quite a lot of variables. It's not just like going down and asking for money. Now, this is the big difference, right? If you go to the county court, you can never get through on the phone. You can never get through on the phone. It's very difficult. You send them an email, they never respond back to it. These people who deal with it, things are clerks there. And if you go and ask them anything like, where's the toilet? They'll say, well, we can't give legal advice. But things that they're meant to be giving you help on, they'll just say they can't give legal advice. Now, if you keep asking them, or you just walk away and walk back and ask somebody else, sometimes you can get them to give you a straight answer, but they're very unhelpful, and it's not really very inspiring dealing with them. Again, that's their job, and they're obviously told not to give legal advice, but they're not giving legal advice. It's administrative advice, but they just don't like to deal with it. Now, the other big thing, so effectively, you use the county court, you have got you can't get costs awarded against you, or there'll be very small costs, like 100 quid there, 100 quid here. Whereas if you go to the High Court, the cost, it's infinite. There's no limit on what costs you can have awarded against you. And when I say costs, I don't mean liability. I mean the costs of the other side's legal representation and their claims preparation time and all that stuff, right, which could be quite considerable. So, of course, it could cost millions. But if you're in the county court, they can spend millions, but they're not going to get more than like 150 quid back, and they well know it, so they won't accrue millions generally. Right now, the other very important thing that I didn't know, but I know now, is if you put things into the High Court, right, you can actually say what level of judge you want to see it, and you can put High Court judge, whatever. And you can also decide what division of the High Court you want it to go in. For instance, the Queen's Bench, you've got Chancery, you've got the Family Division, you've got different events. And if you look on the CPR, Civil Procedure Rules, or the Ministry of Justice website, you'll probably be able to work out which court you can put things in. But again, that's a bit confusing because, for instance, in the Queen's Bench, you've got the Mercantile Court, and you've also got the Commercial Court, and then you've also got the is it the Admiralty Court? I forget it. But anyway, the point is, they both use the same reference numbers. Now, if you were to stick something in one of the divisions, say like you put it in the Queen's Bench and it was meant to go in Chancery, you could actually be penalised for that. You could be charged because you had to file it again. You could be charged for 2 filing fees. You can't be charged 2 filing fees if you put it in, I think it's the Mercantile one or the other one that sounds like it's in the sea. The Commercial one or the Mercantile one or whatever, the Admiralty one. I forget how it works. The point is, they use these words, but then if you ask them what's the difference, they can't tell you because there is no difference, and you can file it in the wrong one and they put it in the right one without changing the fee. So some of these things can be misleading again because they're making what do you think? Well, if they're called 2 different things, there must be a difference. But presumably, but then if they don't treat them differently, they've got the same numbers, the same. They use that a sort of mutually, like if you've used that case number for that one, you can't use it in the other. Can't use it in the other one because they're both part of the same category, and also the judges are the same. So that's quite confusing. But again, it's like nothing to worry about. But again, obviously, if you're doing something yourself, you will worry about this because, of course, you don't want to do it wrong. Now, the other thing is that if you file something in the county court, right, and you try and put some kind of injunction, like interim injunction, as per an application for an interim injunction to be heard, any injunction, no matter what it is, has to go to the High Court. Now, one of the things that you'll find this often has an effect on it. Let's say you're quite a junior and you're in the police, for instance. You'll often have to go to the High Court because there's been an injunction put on somebody, because injunctions aren't allowed to be heard at lower courts. They have to be heard at high courts. So, for instance, you'll get junior police who've like some kind of weird civil disturbance type thing. The person's got an injunction put on them. The hearing won't be allowed to be at the little court in the town. It'll have to go to like the big court. So you know what I mean. It can be quite a minor thing, but if you put an injunction on, it puts it right up. So that's whether it's a criminal matter or whether it's a civil matter. But of course, some civil matters have become criminal if there's an injunction put on somebody, because it will be a civil restraint. It wouldn't be a criminal matter, but if they break the order, then it can become, obviously, the person get in trouble, they go to prison. So, for instance, if you commit contempt of court in either the county court, the civil court, or the high court, you can go to prison. You can get in lots of trouble. You get big fines, all sorts of stuff. You get in lots of trouble. So it was civil. If you start doing what they told you not to do, you can get in a lot of trouble. You don't necessarily get in trouble, and this is again a big massive bone of contention, because of course they don't consistently apply these things. If they don't like look at your face and they're not really particularly scrupulous, the judge will just send someone to prison. Whereas in another instance, they'll let someone do absolute daylight robbery and nothing will happen to them. So it's completely unfair and it's completely arbitrarily applied, you see. So that's something to watch out for. However, as I said, the big difference is the High Court is where you get injunctions put on people. Now, if you're dealing with a big company, right, putting injunctions on them can be extremely effective, because if you're waiting for that court case, let's say they owe you some money, if you wait for that court case to happen, that can take months and months and months. If you want to put an injunction on them to say, for instance, a likelihood of dissipation of assets, you can get that heard within the next 2 weeks, maybe even a week, if you sort of demand it. Say, it needs to be done straight away. It goes to a kind of enforcement department, and you can go in and you can speak to a judge. You can even get it done without the other parties there. Now, in my experience, if you go in and you apply for this on a completely frivolous basis, and you've got absolutely no possible legitimate means of getting it passed without the other party there, the court won't penalise the party for trying to get ex parte hearing. That means without the party hearing, without notice hearing. Now, sometimes you get an ex parte hearing with notice. So you tell the other party there's going to be a hearing, but they're not allowed to go to it. It's just going to be without them, to save them saying, look, well, we need some time to get our paperwork together. So they're going to have it without you. Then you've got to go back with your paperwork. So they might be able to get an injunction in place until you get your paperwork in place, that type of stuff. But you see, the whole point with this is something extremely snide that certain snidey individuals make massive use of, because they don't get penalised for using this. And of course, if you then don't know that they've done this in the background, they manage to serve you your papers but you don't get them, an order can be put in place on you and you won't know anything about it, and then you might break that order. The next thing, the police will be knocking on your door. You see, certain snide individuals in this country are famous for using it, and I've come across people who do it, and they don't get in any trouble, which is a disgrace, but that's the way it works. Now, this is the other thing. You've got the difference there. Yeah, the other thing is that you've got a choice nowadays, and this is where it gets confusing. As I said, you've got solicitors who solicit for business of the public, can represent you in the little court, but not in the big court over important stuff. They can't deal with things, well, they can deal with stuff, but they can't actually go and argue them in front of the High Court. Now, what it's called rights of audience, right? They do not have High Court rights of audience. Basically, they're not considered like capable of dealing in an efficient manner in the High Court. So the only person who can deal with the High Court for something that involves your interest is you, or somebody who's got High Court rights of audience, and I'll explain what that means in a minute. However, you, if you're a business, could be any employee of your firm. So if you wanted to employ someone, you can't get an agent of your firm like a subcontractor. They can't. It has to be an employee. They can. Right. So you've got a choice. It's either you or it's a company. It can be an employee, can represent you. It doesn't have to be legally qualified. It doesn't have to have any rights of audience because they're part of your company. Then you've got barristers, because that's what they're trained to do, and they're not meant to solicit to the public, but there's a caveat which I'll explain in a minute. But the tradition is, remember, solicitors solicit to the public and then they refer you to barristers, so you're paying twice. and then they sort of explain what you want to say to the barrister because you're not clever enough to do it, or some bollocks like that. It's nonsense, but that's the way it works, and you get screwed over by two lots of people rather than one. And also they've got like an excuse whenever they make a mistake, and they go, oh no, he said that, and oh, he must have got confused, whatever. So you're a bit caught between the devil and the deep blue sea, and then you've got a rock and a hard place as well, so you've got like three things to sort of juggle around then. Now, the thing is, so you've got this situation. Do you go to a solicitor or do you go to a barrister? Now, you didn't used to be able to go straight to a barrister, but now what they've got is they've got what's called the public access scheme. Now, the public access scheme, I think a barrister should be practicing for about 8 years. Then he's allowed to go for this public access training program, and that means that it's deemed that he's capable, and that means he's capable of dealing with the public and competent to deal directly with the public. So, what's the point of using the solicitor if you want to deal with an important matter? Because there's no need anymore, because the barrister will come up with that exact arguments. He knows exactly what he's doing. He's not more expensive than the solicitor. You just save loads of money. So the public access scheme is something you really want to look out for, because you don't want to be wasting money on a solicitor. It's totally idiotic to do it. If you don't want to represent yourself, don't bother dealing with them. Now, there is an exception to that, because like the solicitor, so the barrister is now allowed to sort of solicit the business, effectively be a solicitor and a barrister. Solicitors, on the converse of that, some of them have got what's called high court rights of audience. Now, this has been around for a while, but it's not something I really knew about. Now, if a solicitor after their name says advocate, yeah, that means they've done the advocacy course. Now, this is not to be confused with acting as an advocate in the lower courts, because you can get any legally qualified person to do that, solicitor or barrister. But it means that they can represent you in the high court. They're allowed to talk to the judge, all that stuff. And remember, they're not allowed to otherwise. So now you've got two different types of people who can do the whole lot. Now, generally, in my experience, I've only ever dealt with two solicitors or advocates, both extremely dishonest, extremely dodgy. One of them was very sharp, very intelligent, and very dishonest, and one of them was very not very clever, very dishonest, and I don't know. I can't really work him out. But the point is, they seem to be a bit of a different breed. They're kind of like your higher echelon solicitors, the ones that get paid more money. So you don't normally get like a shit solicitor who's got like a low paid one who gets high court rights of audience. If they're in your hometown, the chances are they haven't got. You know, if you live near London, in London, whatever, then they probably, there'd be quite a few of them. Anyway, so that's the thing. Now, I phoned up the bar recently, the bar council, to see if I could work out how many of the advocates were they signed up with them or what. And it turns out they don't have anything to do with the bar, even though they effectively act as barristers. Now, then I phoned up the Solicitors Regulation Authority. Now, they do actually regulate the advocates as well as just normal solicitors. And they said to me, well, we used to have a special course that they did, and then they had to sign up to some new guidelines, because effectively they're acting as a barrister as well. But we've dropped that now, and all of the rules about how they behave in court are just the same as the general solicitor's rules if they were being an advocate in another court. Now, this is quite interesting, because then it begs the question, what's the point of this rights of audience stuff? It doesn't really seem to make any sense, because if they're saying that it's fine to just use the same rules as in the lower court, there's no need to have an extra set of rules, and there's no extra set of regulations on them. It begs the question, what's the point? And that's been allowed. What's the point of having what a barrister's doing that's any different? It doesn't really make any sense. But the important thing that I found about this particular aspect was, if you've got so you've got this situation where you've got I got brain freeze. So basically the point is now you've got to really think twice before you take somebody on as a solicitor, because if they haven't got high court rights of audience, they can't really do lots of the stuff. When you see the start of the video, lots of the more important things that you'll ever want to do will involve going to the high court and people going in and speaking to judges about stuff. And if they can't do it, it's a complete waste of time taking them on, because they can't do it. Because you will not believe what they want to do. They'll want to charge you to talk to the person about what they want them to do. So even if that person had done the public access scheme, they'll want to talk to him, to tell him, to make sure he knows what you want him to say, right? And again, similarly, if they got one of their mates who'd done the advocacy course, they'll have to go in and speak to him to make sure he knows what you want, because you're not allowed to talk to him because you're not capable, because you're instructing them and they're going to get money over absolutely everything and travelling time. It's a complete and utter con. Do not be fooled by it. As I said, with these things, this is all stuff I've picked up. I didn't know any of this to start off with. It's just stuff you pick up. So you've got solicitors, barristers. Now you've got barristers who've done the public access scheme who can solicit, and you've got solicitors who can solicit because they're solicitors, aren't barristers, but can act as barristers because they've got high court rights of audience, and under their name it says advocates. So you've got solicitors, solicitor advocates, barristers, and barristers who've got the public access scheme. I would say we really want to come to a situation where you don't just get barristers and you don't just get solicitors. They have to they'll merge into one. It'll be like America, because there's no excuse for it. It's just an excuse to rip people off. I did actually find a situation a little while ago where there's a possible exception to this, because I'm just talking about things that I've come across, and I'm not giving I'm just giving my point of view from what I've seen. So there's possibly gaps in my knowledge. But the point is, I went to the Rolls building a while ago, which is part of the High Court. It deals with business law, and they do like winding up petitions and stuff like that. They've got a judge in there, but they're called a registrar in that particular job. Like I explained about masters, they are High Court judges, but they're called masters. They're effectively acting as secretaries. So the registrar, and that room has got probably 75 barristers in there with the little wigs on, all sitting in the front. Two sort of columns of them, and then a little way up the middle. So the people who are like standing around the back and sitting on the chairs at the back, who come in to sort of argue about they want some more time to pay this debt off, they don't want their company wound up, that type of stuff. You can go in there, and there's all the people with the little hats on, like the wigs on, loads of them. Now, what happens with all these people who are sitting there? You think that they seem to be wasting a lot of time. There's loads of them in there. They're just sitting there. Now, this is the point. Possibly, it does look like there's a lot of wasted time going on. However, there's an efficiency there, because what happens is each of those barristers will often have numerous instructions to just stand up, say something to the judge like, I've been instructed by so-and-so to say this about this firm, blah, 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 blah. They sit down and there's some kind of order given, or there's some extra time given. So these people actually have numerous commissions, if you like, that day. Now, I don't think they're necessarily very high up. A lot of them look quite young. So I think there is actually a function of barristers that isn't just waiting around to be given Chinese whispers off a solicitor. Like that there is an actual function for people who just act as barristers. Like, you could justify letting people qualify, doing that and just dealing with that kind of stuff for a while, because the thing is, on the other hand, though, there doesn't really seem to be an awful lot of thinking involved with that job. It's basically like working on a checkout or something like that, but obviously a lot less work and a lot less mentally demanding. But the point is, there is a function that they perform, because of course you're not allowed to pay just anyone to go in and do that. They have to be a barrister. So if you've talked to a solicitor to go and do your work on your behalf to do with your company, they aren't allowed to do it. They have to use a barrister. And to be fair to them, because you don't know, they go through like hundreds of these petitions a day. Like, if that barrister's in there, he's going to have to wait around. He's not going to know when it's going to be. So if he's got 2 or 3 cases he's dealing with that day or that afternoon or whatever, then there's a sort of like, it's probably as efficient as it possibly could be under the current system. So that's quite good. Now, there's another thing I'd like to mention. I don't know what the word is, but there is a word for it. I was working for the government a while ago, not working for them as in I was an employee, but I was a contractor. And when you are trying to instruct a solicitor to put clauses in an important contract on your behalf to get the weasel words right, one of the things that happens is you have to, and this is absolutely scandalous, and you'll be disgusted to hear this, but it's absolutely standard, right? You have to get a solicitor who you want to do the wording, so you'll get an appropriately qualified solicitor. Let's say on a road job that's going to be worth a few billion, a roads contract, term maintenance contract, you're going to have different people bidding for different sections of a massive road network, that type of stuff. So you'll get an appropriately qualified solicitor to do that particular clause in that particular contract, or a bit that you require some help with because it's a lot of money rides on it. And what you do is you then have to get another solicitor to listen to what you want, the solicitor you want to do the clause for you, because they say you're not competent And a lot of public servants obviously aren't competent to do anything, which is why they're in the public sector. But not all of them are incompetent. And also, if they're not competent to know what they even want, what on earth are they doing being in charge of instructing anybody to do it anyway? So it's, you know, there's a lot wrong with the whole concept. But what you have to do is you have to get another solicitor to tell the other solicitor what you mean, so that the solicitor who you've chosen, because you want them to do it, because you think they're specialist enough, and these will be the top end ones, right? They might kind of trick you and not really understand what you're saying and not do a very good job. Every one of these, like, you can't deal directly with the person because. It's just a con to rip you off, encourage ambiguity, encourage Chinese whispers, and waste money. And it's just jobs for the boys. It's a way of making something that should be very simple incredibly complex and cost a lot of money. So I've hit a few different things there, but they're all based on things that I've found from my own personal experience through work or my personal dealings. So take it as it is. As I said, nobody's ever going to give you an unequivocal opinion. Like if a doctor gives you an opinion, it's not going to be unequivocal, it's just their opinion, and they're allowed because they're a doctor. If an accountant gives you an opinion, it's their opinion, and they're an accountant. And if a lawyer gives you their opinion, it's their opinion, and I'm just giving you an opinion based on what I've found and my experience. And I'm not going to give any massive loads of pre-qualification about it not being legal advice like lawyers constantly do, because it is legal advice, isn't it? This is what I've found, and from my advice, that's what, you know, if you construe advice, you're perfectly entitled to. And if you then go and like apply it to a situation wrongly, or you find it didn't apply in your particular situation, well, you might as well just sue me then, mightn't you? Because it's not going to get you anywhere, because I'm just saying that's just the way it is. And all this ridiculous pre-qualification of everything and saying it's not legal advice, not legal advice. Again, this is more bullshit to create the mystique of the law being very complex. It is complex. It's complex to trick you, so you spend lots of money and you go round and round in circles and you never get anywhere. That's the whole point of it. It's a snake that eats its own tail, only it's getting like food sprinkled on it by all the suckers. Anyway, thanks very much. Bye now.